Thank you. Senator Grassley, I think.
Yeah, I would like to give some rebuttal to some of the things that's been said based upon some of the stuff I've been involved in that have involved subpoenas. I've long supported Congress's constitutional mandate to conduct oversight under administrations of both parties and including through this committee. I voted with Senator Specter to support various subpoenas issued by this committee during the investigation of the firings of several U.S. attorneys during the Bush administration. I even supported the committee's contempt resolution against 2 of its witnesses. So I will support this authorization so that the chairman can effectively continue his oversight. And I think my remarks also apply to the amendment by Senator Hirano. I'd like to remind my colleagues that during my time as chairman, the committee investigated alleged collusion between the Trump campaign and the Russians. This included a careful examination of the events surrounding the June 9th, 2016 meeting at Trump Tower. Committee staff interviewed 5 individuals who participated in that meeting, including the president's son, 4 individuals with ties to Russia, and collected documents from several others involved. At the ranking member's request, the committee interviewed an additional 6 individuals and reviewed nearly 1,000 pages of additional documents that they provided. This group included advisors to the Trump campaign and the transition team, as well as a business associate of the president. I subpoenaed Paul Manafort with the ranking member Feinstein's agreement to appear at a hearing and provide testimony. Instead of publicly testifying, Manafort voluntarily agreed to an interview with my and ranking member Feinstein's staff. But the ranking member's staff then refused to interview him and objected to my staff doing so without them. After pressing so forcefully, ranking member Feinstein changed her position and wanted to release Manafort from a hearing subpoena and invitation on the eve of the hearing. So we did not interview Manafort. On March 2018, I made 2,500 pages of transcripts, written statements, and exhibits from the committee's Trump Tower investigation available to the public. The committee also reviewed records from Manafort, Michael Cohen, and Kushner, nearly 5,000 pages of documents produced by the Trump Organization and the president's son, over 30,000 pages of documents supplied by the Trump campaign, and 180,000 pages from the transition team. The committee has never received any emails from the Democratic National Committee or the Clinton campaign, even though we repeatedly asked for them. Of course, the ranking member wouldn't support subpoenas of those. The ranking member also didn't support a subpoena for Fusion GPS records. We received tens of thousands of blank pages and unresponsive material from Fusion. The only way to get compliance was through a subpoena, which never happened. Staff did receive multiple briefings from technology companies pertaining to the Russian influence campaign and received tens of thousands of pages of related material that they supplied. During the course of its Russia investigation, the committee also held a hearing on Foreign Agents Registration Act oversight, submitted countless oversight requests to federal agencies and the special counsel's office, and reviewed sensitive and classified documents produced by the State Department, Justice Department, FBI, and intelligence community. We didn't find a single shred of evidence to support Russia collusion narrative. We found quite a lot of evidence that there were problems with the way that the FBI conducted its investigation, and that's based on roughly 4 years of work. So that's why, that's where the unanswered questions still are, and I'm glad that the focus we're now taking is very legitimate and right. As far as I'm concerned, this subpoena authorization is ripe for a vote. However, during the course of the inquiry, we found the only real collusion that took place was between the Democratic National Committee, Clinton campaigns, and Russian officials. The DNC and the Clinton campaign hired Fusion GPS, which in turn hired Christopher Steele. Steele created his dossier, which was based in part on Russian government sources connected to the Russian presidential administration. Some of those sources supported Clinton. Based on declassified footnotes from the Inspector General's report, the intelligence reports indicate that information contained within the dossier was the product of Russian disinformation. That begs the question then, what did the Clinton campaign know about the dossier, and when did they know it? Or better yet, what did Hillary Clinton know about the dossier, and when did she know it? My Democrat colleagues don't seem to interested in finding answers to those questions, even though the Steele dossier is the only real evidence of Russian collusion with a presidential campaign, and it happens to be the Clinton campaign. In conclusion, I'd like to insert into the record a complaint filed by the nonpartisan Campaign Legal Center before the Federal Elections Commission. The complaint states that the DNC and the Clinton campaign wrongfully reported millions of dollars in payments to law firm Perkins Cooley and legal services when some of those payments were actually for Fusion GPS and their opposition work with Steele against Trump. As I'm sure you all will recall, Mark Alias, one of Clinton's lawyers, publicly denied any involvement with the Steele dossier, which was false. We now know he made sure Fusion's and Steele's work continued in order to undermine Trump, and it certainly looks like the other side wants to do everything it can to not get that information out.